Here, I'm going to continue our discussion about the rules about lawyers representing organizations as clients. That is, where the client is an entity rather than a person or a few individuals. And here we're going to focus on Rule 1.13 sections F and G. I call these sections, I am not your lawyer, and I think you'll see why as we proceed. Rule 1.13F says, in dealing with an organization's directors or officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. Now, comment 10 to this rule helps unpack this for us. It says a lawyer should advise any constituent with adverse interest to the organization about the conflict of interest that it poses if he talks to them about the matter, that the lawyer cannot represent the constituent, that such a person may wish to obtain independent representation. Let's talk about each of these before we move on to a famous example from a real case. So suppose the lawyer is confronting a mid-level manager about something unlawful the lawyer is doing that could subject the entity to liability or other severe financial losses. The lawyer must explain to the person that the lawyer represents the entity and not this individual, even if this individual is a person who hired the lawyer to represent the entity. And that even if the lawyer represented the individual and the entity, then there would be a potential conflict of interest for the lawyer. So usually the lawyer needs to tell the person, I am not your lawyer, I am the company's lawyer. And the lawyer should include with this that the individual should get their own lawyer, obtain separate legal representation about this because their interests are in conflict with the employer's. So when you represent an organization, especially a large organization, let's talk about the extremes of the corporate hierarchy. At the top end, you might have a president or CEO who's used to thinking of everyone around them as their subordinate, somebody there to do their bidding. Some corporate managers run the office kind of like their personal fiefdom. And it can be awkward for the lawyer in that case to keep explaining, I am not your lawyer, I'm the entity's lawyer. At the other end of the extreme, let's say you have the lowest level, entry-level unskilled laborer, and right, someone who was just hired to work in the warehouse or to drive a delivery truck or something like that. And the corporate lawyer, especially in-house counsel, may be the only lawyer that they regularly have contact with. And so they may just assume, you're my employer's lawyer, so can I ask you about my child custody matter? Can I ask you about my DWI or something like that? And they expect the lawyer to provide their legal services, and you're going to have to explain, I'm not your lawyer. Now, for our famous example. In another part of this course, I mentioned a case about a horrible accident that happened between a Dr. Pepper delivery truck that was operated by Coca-Cola and a school bus full of children, and more than 20 kids died. I brought it up to talk about the plaintiff's lawyers in the case when we were doing fees and their controversial contingent fees, which were millions of dollars, even though the case settled quickly. Now it's time to talk about the defendant's lawyers. The truck driver was seriously injured but not killed in the accident. And so right after the accident, some of the company's lawyers visited the injured truck driver in his hospital room and asked him what happened. The driver said some things that incriminated himself regarding the accident. Basically, he was intoxicated at the time. The lawyers had identified themselves to this driver as lawyers for the company, that is his employer, but at no time did they warn him that they were not his lawyers. Because he basically admitted that he was intoxicated when he was driving this truck, his statements could have helped the company blame him and avoid vicarious liability, because his substance abuse while driving the truck was arguably acting outside the scope of his employment. Now, in this particular situation, the lawyers actually have a duty to inform their corporate client, the corporate officers and directors, of the truck driver's admissions, right? Because it's very important to the legal representation. We have an admission from our driver that he was drunk or high when the accident happened. Now, in reality, the company in this case quickly settled anyway, perhaps to diffuse the media attention or bad publicity that it was generating. It was making national news. But the employee's admission could have been used to shift all the blame to the employee if the case had gone to trial. So I hope you can see how this is exactly what Section F of Rule 1.13 addresses. A lawyer has a duty to clarify to employees of the client that the entity itself is the client, because a lot of people will just assume that the lawyer is looking out for their interests as well. And then the person may say something implicating themselves in a crime, or that will get them fired, or have them be held liable for what happened. And note that the conversation will not be privileged because the person is not the client. The entity is the client. So lawyers could actually be forced to disclose what was said in the conversation. Let's move on to the last section of this rule. We're almost done. Rule 1.13G says, a lawyer representing an organization may also represent any of its directors, officers, employees, members, shareholders, or other constituents subject to the provisions of Rule 1.7. And then Section G continues, if the organization's consent to the dual representation is required by Rule 1.7, the consent shall be given by an appropriate official of the organization other than the individual who is to be represented, or by the shareholders. So this is actually pretty clear, but make sure you grasp what's being said here, because it's such a specific requirement that it would be very easy to turn it into a gotcha-style multiple choice question on an exam like the MPRE. To explain this, let's go back to talking about, let's say, a vice president or a president who will be a co-defendant along with the entity itself, either in a personal injury lawsuit or a government enforcement action. Here, assume we are not talking about the person who is defiant towards the lawyer's warnings, but rather this involves a past action that has now generated litigation, or maybe the litigation is based on a false claim or false accusation. Either way, there are plenty of situations where the company and, let's say, the corporate executive have the same interests in the matter. They want the case dismissed, or to win at trial, or to settle quickly within their insurance policy limits. Or maybe they want to be acquitted of criminal charges. Remember that even corporations can sometimes face criminal charges, as well as the individuals who run it. So this is a classic scenario of joint representation. The lawyer is representing co-defendants, or sometimes co-plaintiffs, like in a defamation case. And one of the co-clients happens to be an entity, and the other is a leader, like a director, manager, or officer within that entity. So as with any other joint representation, under Model Rule 1.7, which is our basic conflicts of interest rule, the lawyer has to obtain informed consent in writing from both clients that are being represented together. Remember all the things that can go wrong that create a potential conflict of interest with joint representation. They could have different positions about whether or when to settle the case, about how to allocate a settlement, whether it's a payment being received, how to divide it up, or a payout. Or they could end up with cross-claims against each other. So Section G is about a very specific issue for this specific scenario. The lawyer is asked to represent an entity and one or more of its officers, managers, or directors as co-clients in the same matter, which may be okay as long as the lawyer gets informed consent in writing. Well, some individual has to give that written consent on behalf of the entity or organization, and it cannot be the same individual who is the co-client giving consent on behalf of themselves. Someone else in the organization must sign off on this joint representation besides the individuals being represented by the same lawyer as a corporation in the same matter. And that concludes our discussion of Model Rule 1.13.